And I think Gustavo's presentation really highlighted some of the specific challenges that have arisen with investment treaties and some of the critiques that have been made of them. And I want to back up a bit and talk a bit more about investment treaties and what they are, and then some of the research that I've done looking into the tensions between investment treaties and domestic law and the extent to which they really pose a problem for policy space and the government's ability to take measures in the public interest. So in terms of investment treaties, now what they are, really, there are about 3,000 of them worldwide, and they're instruments concluded between governments. And one justification for them is the idea that they will lead to increased foreign investment, with the idea that that investment in turn will lead to sustainable growth and development. Whether or not investment treaties actually do lead to increased investment, I think that's increasingly open to question. The data is very inconclusive on that. But that was one of the reasons why they're concluded. And what they do is they provide certain rights and protections for foreign investors. And if the government receiving the investment, which we call the host government, does something to breach the treaty, the investor can then sue the government directly in investor-state arbitration, bypassing the courts entirely. So rather than go as any type of domestic citizen or company might do through a domestic court procedure, foreign investors under the treaty, multinational companies, can use this arbitration mechanism to sue a government. Often the disputes are behind closed doors, which is why many people don't know about these treaties. I can tell you many of my friends have no idea what I'm working on. So many of the disputes happen behind closed doors, and they're also very expensive. The average cost of litigating a case is now $8 million. And I think that was probably from 2010. I think the number is probably higher. And damages can be huge. They order, if you've got, for example, a dispute under the WTO and a state is found to be liable, the remedy is generally that you remove the offending measure, but you don't have to pay damages. Under these investment treaties, the investor can get compensation directly. So you've seen Ecuador was ordered to pay Occidental $1.8 billion. So the awards can be massive. Not all of them are that big, but they can be significant. So that is what investment treaties do, and what some of the critiques of them are is this direct right of action against the government. So, I think that they have the potential to promote sustainable investment and to catalyze flows of investment into countries and promote development. But right now, the models that are being used are not living up to their potential. And I think there are a number of reasons for that. And one is the way that the standards are being interpreted and applied. As Gustavo said, the treaties can contain vague wording, such as one core obligation to provide fair and equitable treatment. And the way that's been interpreted has been, I would argue, very strict on governments. So what I've been looking at is the extent to which this fair and equitable treatment standard in the investment treaties hinder governments' abilities to change laws and regulations for the public benefit, but in ways that might negatively impact a company. So, for example, when a government changes its tax regime, when it imposes new environmental regulations, when it changes its labor laws, when will it have to actually compensate the company for doing that? Or when will the company have to bear those costs itself? So looking at how the investment tribunals deciding these cases come out on those issues, and then comparing that with how domestic courts have treated those issues. Because these are issues that domestic jurisdictions have been struggling with for hundreds of years. So it's not new questions. And what I compared is how U.S. courts would treat these issues, looking at U.S. courts because it's generally considered to have strong property rights protections, looking at how U.S. courts would treat these issues and then comparing that with how tribunals do. And what I do see is that investment tribunals have been holding governments to a higher standard of conduct than domestic courts in the U.S. And this then requires governments and the public to bear a greater share of the risk and costs of public interest and regulatory change. And this has implications for countries such as Ecuador, who have found themselves being sued under these investment treaties before investment tribunals. And so I want to talk about highlight some cases in the U.S. and some doctrines in the U.S. and how those have been applied, and then contrast that with some of the cases that have been brought against Ecuador under investment treaties. So in the US, you've got a couple important principles that shield the government from liability. The first is the Sovereign Acts Doctrine. And the Sovereign Acts Doctrine is that this rule says that a government is not going to be liable for acts of general applicability in the public interest that are taken for a public purpose, even if that impacts an investor-state contract or an investment. But that's the general default rule, is that there's no liability for sovereign acts. The second key doctrine is the unmistakability rule, and that is an exception to the Sovereign Acts Doctrine. And it says, if you as the government promise a company that you will not raise its taxes or you will not impose a new environmental requirement on it, if you make that promise in an unmistakable, clear way, in a legally binding way, consistent with all domestic laws, you will then be bound by that. And if you later change your law in a way that hurts the company, you will have to compensate for it. So you've got the general rule of sovereign acts defense, and then this exception for an unmistakability doctrine. And I'll give an example of how this was applied. I mean, these doctrines have been around for a while. So in, I think, the late 19th century, there was a case where the U.S. government, one of the legislatures promised an investor who was building up a municipal water services facility, promised them to forever exempt the facility from state, county, and city tax. Well, about 10 years later, the state enacted a lot of taxes, new taxes. The company didn't pay and said, you exempted us forever from all of these taxes. The company didn't pay, so then the state seized its assets and said, well, you didn't pay, so now they're ours. The case went up to the Supreme Court, and the Supreme Court said, look, when the legislature passed that law, it intended to forever exempt this company from taxes. But it didn't necessarily promise to never change that law. And so it was very deferential to the government and allowed it to change the law. And I found that that was a very striking case, and I think that's one of the more extreme examples of deference to regulatory change. But you've seen the U.S. courts do that in a number of circumstances where, in particular, the issue relates to taxation power, to the ability to change rates and tariffs for public services infrastructure, and the government's ability to react to certain crises, like new environmental risks that are discovered. The Deepwater Horizon raised some cases relating to these issues, too. So the courts are pretty deferential. And then a third important rule then is this notion that you can't apply the doctrine of estoppel against the U.S. So if I, as a government actor, promise a company that it will not have to comply with new environmental laws, if I don't have legal authority for that promise, later on the government is not going to be bound by it. There's not something that the company can't say, well, I relied on your promise, and even though your promise wasn't legally binding, I relied on it, so I'm still going to be able to enforce it against you. The courts in the U.S. say, we're not going to bind the government to promises made by rogue actors or people who don't have the authority to make these promises. They have to be done in a proper way, in accordance with law, and that's the only way that they're going to be binding. So those are the main contours of U.S. law. You've got the Sovereign Acts Doctrine, the unmistakability rule, and the rejection of estoppel against the government that really shield the government from liability for regulatory change that impacts the operation of a company. And this has enabled the government to be able to change tax laws, tariff structures, royalty rates, environmental and social standards without having to compensate businesses for the costs of those changes. But so what we see in investment arbitration under the treaties is much different. They've been much more willing, I'll step back a bit. The cases there are about 600 cases now, and there's no system of precedent. So that means that one tribunal can do one thing and another tribunal can do something entirely different. And so if I can give an example of what I'm supporting, and someone else might say, well, there's an example where the tribunal didn't really do that. But I think for states and thinking about the system, it's important to think about also the worst case scenario. Because when you get sued by an investor, you're going to have to defend it, and there's always a chance that the tribunal is going to go the wrong way. So I really am kind of raising the worst case scenario decisions, but they do happen. So I would say that they've been generally much more willing to find that investors have a right to be protected against the risk of regulatory change, and they have a right to be compensated for that regulatory change. Tribunals, they don't always require the promises made by governments to be legally binding or for the promisor to have the authority to make the promise. and they don't require that the promise be clear or unmistakable or public. So instead, what tribunals have done is that they have inferred a promise or a commitment against regulatory change from statements or representations made by government officials, even if the official didn't have the authority to bind the government to that promise. Tribunals have also inferred the existence of these promises from the general legal framework, saying that the investor has the right to rely on the stability of that framework, and should the government wish to change the laws, it should have disclaimed that intent at the outset. Tribunals have also not been concerned about whether the promise to be protected against legal change was legally valid, or as I said, whether the official giving the promise had the authority to do so. So they allow the doctrine of estoppel to be applied against the government. So if I, as an actor, promised this company that it didn't have to comply with the environmental laws, even if I had no ability to give that promise, then that company can then use an investment treaty to say, well, now I'm exempted from this environmental law because this rogue actor gave me that assurance. So I'll highlight two cases in which these situations arose, and both involve the same claimants, the same respondent, but under different facts, and both were against Ecuador, and both were brought against Ecuador by Occidental. So in the first case, it was Occidental versus Ecuador, decided in 2004. And there, the government had enacted a tax law in 1999. It was around 1999, they enacted a new tax law, and Occidental was subject to that. And then there were some different interpretations of that tax law over the ensuing years. Occidental challenged the interpretations under domestic Ecuadorian law and wound up losing some of the cases, not all of them, but some of the cases, and then wound up challenging them again before the tribunal. And what the tribunal said is that Occidental had a right to a stable tax regime and not the changes, and said there's an obligation under customary international law not to alter the legal and business environment in which the investment has been made. So that stands in really, I think, direct contrast to the sovereign acts rule that you would have in the US, where there's a general presumption that the laws are going to change. That the presumption is not for stability, the presumption is really for change. So the second case is Occidental versus Ecuador, and that one was decided in 2012. And there, the tribunal cited representations allegedly made by a representative of Petroecuador during contract negotiations for why the investor had the right to expect that the tax regime would not change. They said that representations made by someone from Petroecuador caused this reliance felt by Occidental that the tax regime would stay the same, and therefore when Ecuador later enacted a windfall tax regime, then Occidental had the ability to expect that that wouldn't apply to it. So that was a case where there was an actor making some kind of statement, probably not binding under domestic law, but that the tribunal seized on in order to exempt Occidental from those taxes. So I think if you look at the cases, and these are just a couple of examples, and I could cite many other ones. If you look at the cases and you compare U.S. courts' deference to government actions with what the tribunals are doing with governments, I think it raises a question of how you want to allocate the risk of regulatory change, private rights versus public interests, and where those decisions should be made. Should they be made in a domestic forum where in legislatures, in courts, where the government actors are more accountable to the public, or should they be made in an investor-state arbitration where people generally don't have access to the cases and the decision makers aren't accountable to the public? So it's I think a major system-wide question of how these decisions should be decided and how you want to have the allocation of rights and liabilities. And I think I would say that the tribunal's decisions in this sense, they risk having a significant impact on government policy space. I think they override domestic choices regarding the allocation and strength of private property rights. And they hinder really the ability of investment treaties to be seen and used as tools that do advance sustainable development. So I think that comparative approach is insightful for that. And there's also, if you're interested, have a paper on our website that discusses the cases in more detail.